to today's webcast, Drug and Alcohol Testing and Human Rights, delivered by the Ontario Human Rights Commission. My name is Nancy Mabin, and I am part of the professional development team at HRPA. Before we begin the presentation and to provide additional time for individuals to log in, I'd like to alert you to a few of our PD programs. Next week, on Thursday, November the 10th, we will deliver Building Success with Succession Planning. Succession planning needs to be considered at every stage of your business's development. Join HRPA and succession planning expert Alan Ward for a one-day workshop to learn everything you need to prepare your organization's talent needs now and in the future. Learn the difference between replacement planning and succession planning, the purpose and value of systematic succession planning, and the key steps and process to lead succession change. On that same day, Thursday, November the 10th, we will also deliver Empower Performance, Transform Your Culture, and Increase Autonomy. How can HR executives, professionals, and managers get employees to be present, to be responsible, and to be productive? The secret is to build a culture of empowerment. Based on his book from McGraw-Hill entitled Operational Empowerment, Collaborate, Innovate, and Engage to Beat the Competition, Sean Casemore will walk attendees through the proven strategies to transform a culture into a highly motivated, productive, and engaged community. Learn specific tactics on how to introduce empowerment, how empowerment will increase engagement, and the approach to converting directive managers to facilitative leaders. On Tuesday, September the 15th, over the lunch hour, HRPA will deliver Employment Law Year in Review. Employment law is constantly evolving. This webinar will focus on the latest trends in the case law and help HR professionals keep abreast of any major developments that may impact your workplace. For further details on these and other PD programs, please visit our website at www.hrpa.ca/professional development. And now for a few quick housekeeping remarks. If at any time you experience technical difficulties, please send an email to pdwebinars@hrpa.ca or indicate the issue to us via the Q&A panel on your screen. Throughout this webcast, we encourage you to ask questions, and we will try to get to as many as we can in the time that we have. You can also download today's presentation by selecting the link that can be found in the resources panel on your screen. And finally, your feedback is very important to us. Please take a few minutes to complete the survey that will be sent. The recertification code for those individuals who require it will be provided on the last question of the survey. And now I'm very pleased to welcome today's facilitator, Anya Kater. Anya Kater has a master's degree in social work and works as a Senior Policy Analyst at the Ontario Human Rights Commission. Anya develops and drafts public policy on a range of human rights and social justice issues. She also delivers public education and undertakes consultations with stakeholder groups and the broader public. Anya is joined today by Dora Nip, Human Rights Education and Change Specialist. Welcome.
Thank you, Nancy. Today's presentation will take about half an hour, so let's get started right away. I'll turn the mic over to Anya.
Hello, everyone, and thank you so much for having us today. Today, we're going to give you an overview of the Ontario Human Rights Commission's updated policy on drug and alcohol testing. There'll be time at the end for questions and answers. But first, let's get started with a poll question. In what sector do you work? Manufacturing, construction or resource extraction, for example, mining, with the union or the government, healthcare or social services, trucking or transportation, in hospitality or tourism, law enforcement, law or advocacy, education, or other. So please click the appropriate response.
Yeah, and we'll just wait a few seconds and we'll just give you a chance to indicate your response. And let's see what pops up. Okay, so Anya, we've got quite a cross-section: manufacturing, construction, government, healthcare. Okay, that's good to know.
Great.
All right, let's get started. Now, it's not always easy for employers or employees to know their rights and responsibilities around this issue. The law and science in the area is constantly evolving.
That's right, Dora. So here are some situations that we thought of that might sound familiar to you.
Now, I'm just going to forward it. There we go.
You own a startup mining company and have big plans for expansion. You want to put in place random drug and alcohol testing as a safety measure. Is this allowed under Ontario's Human Rights Code? You apply for a job as a forklift operator. You receive a job offer that's conditional on passing an alcohol screening test. What are your human rights in this situation? I'm going to help you figure out the answers to these questions by taking you through the Ontario Human Rights Commission's, or OHRC's, updated policy on drug and alcohol testing.
Sorry. Okay, so Anya, what does the policy cover?
Well, it covers the following. The OHRC's interpretation of the current state of the law in Ontario relating to human rights and drug and alcohol testing. It also covers the code rights of employees or job applicants, the employer's obligations under the code, and some of the current controversies around drug and alcohol testing. The policy also has examples to help you navigate situations, a summary section with general advice, and tip sheets at the end for quick information on the different types of testing. We've selected some of the sections of the policy to talk about today, but reading the policy itself will give you more information. Drug and alcohol testing is one way some employers try to ensure safety at work. While some Canadian industries carry out testing, it's far more common in the United States. Testing is controversial because it reflects a collision between workplace requirements and employees' human rights and privacy rights. Testing can raise particular human rights concerns for people with addictions to drugs or alcohol. Addictions to drugs or alcohol are forms of disability. People with addictions to drugs or alcohol are entitled to the same protection under the Human Rights Code as people with other disabilities. The OHRC recognizes the distinct disadvantages that many people with addictions face, which include extreme stigma, lack of societal understanding, stereotyping, and criminalization of their addictions. If drug and alcohol testing policies don't respect human rights, they can limit people's job opportunities. This can contribute to the stigma and exclusion that many people with addictions face. Overall, drug and alcohol testing may discriminate based on addictions or perceived addictions. If it has a negative impact based on disability or perceived disability, testing may only be justified in certain circumstances. Let's begin with the scope of the policy. This policy focuses on Ontario workplaces where safety is a workplace objective. Keep in mind that under the code, it may be hard to justify drug and alcohol testing for jobs that involve few safety risks.
So Anya, what doesn't the code cover?
The code only applies to organizations covered by provincial law. It doesn't apply to airlines, trucking or bus services that cross provincial or national borders, and other employers regulated by federal law. These have to comply with the Canadian Human Rights Act. The code prohibits discrimination at work based on 16 grounds, including disability. People may be protected by the code when their drug or alcohol use becomes an addiction. In medical terms, this is called a substance use disorder. They may also be protected when they may not actually have an addiction, but they're perceived to have one. For example, if an employee is denied a promotion because her manager thinks she has a drug addiction, this could be discriminatory. Finally, people may be protected if they had a drug or alcohol addiction in the past, but they no longer have an ongoing disability.
I think some examples would be helpful.
Okay, here's an example that might be familiar to some. An oil refinery introduced a drug and alcohol policy that required all employees in safety-sensitive positions to tell their employer about a current or past substance abuse problem. One employee disclosed that he had had an alcohol abuse problem over 7 years earlier. Although he was in remission, this employee was automatically reassigned to a non-safety sensitive position. The employer also required him to complete 2 years of rehabilitation and abstain from drinking for 5 years, among other things, before he would be allowed to return to his original job. What do you think about the policy? Well, the policy was found to be discriminatory. The decision to automatically reassign the employee and put these restrictions on him were based on his past addiction. It didn't take his individual circumstances into account, and it couldn't be justified by his employer. Drug and alcohol testing is a form of medical examination. Even when it's introduced in good faith, it can negatively affect people based on addiction or perceived addiction. This is called prima facie discrimination, or discrimination on its face.
Can you provide some examples of how drug and alcohol testing could negatively affect people based on disability?
Sure. Testing can raise human rights concerns if it leads to discipline, dismissal, or refusing to hire somebody based on an addiction or perceived addiction. Imposing inflexible extra job conditions on somebody, as we saw in the last example. Not accommodating people with addictions to the point of undue hardship, or not respecting somebody's dignity or confidentiality during the testing process. Under the code, drug or alcohol testing that leads to these negative effects based on addiction or perceived addiction can only be justified if the employer can show that the testing policy is a legitimate or bona fide requirement. That's called BFR for short.
And what's the test for a bona fide requirement?
The Supreme Court of Canada has designed a 3-step test. These steps are listed here, all on this slide, but I'm going to go through them one by one. So this involves a little bit of legal language, so please bear with me. So let's say that an employee with an alcohol addiction gets automatically dismissed for testing positive for alcohol because he's violated his employer's alcohol policy. He files a human rights claim, and he's able to show that the adverse treatment is connected to his disability. So to justify the termination, the employer would have to show that the testing policy was, 1, adopted for a purpose that's rationally connected to performing the job. The purpose of drug and alcohol testing should be safety, and this needs to relate to the duties of the job. That's partly why when we see drug and alcohol testing policies, they're mostly in workplaces where there are safety-sensitive positions. For jobs that involve fewer safety risks, it would be hard to show this rational connection. So, in this case, can the employer show that there is a rational connection between the purpose of the testing policy and the employee's job duties? For the second step of the test, the employer would have to show that the testing policy or program was adopted in an honest and good faith belief that it was necessary to fulfilling that legitimate work-related purpose. So, can the employer show that there is a genuine belief that testing is necessary to achieve workplace safety? Finally, the employer would have to show that testing is reasonably necessary to accomplish the purpose, and that it's impossible to accommodate the person without imposing undue hardship on the employer. Undue hardship means excessive costs or significant health and safety risks. So is testing really necessary to identify people who can't do their jobs safely because they're impaired? Looking at the method of testing, including the ability to measure current impairment, are important here. Also, has the employer explored other ways that may be less discriminatory or intrusive to achieve safety? This step of the test also looks at whether the needs of the person with the addiction have been accommodated to the point of undue hardship. If testing causes negative effects on people based on disability or perceived disability, and employers are unable to meet any one of these 3 steps, the testing program or policy is discriminatory. Our policy emphasizes that employers should design their testing programs with these BFR steps in mind. This way, they can anticipate and avoid potential discriminatory effects on people with addictions or perceived addictions. So the policy has a series of questions to help employers apply the BFR test.
And I think those questions might be helpful.
Yes, and these 3 key considerations lay out more principles and guidance. So the objective of doing testing should be to measure current impairment. That is, whether the employee can perform the essential job duties at the time of the test. It shouldn't just be on detecting, it shouldn't be to just detect the presence of drugs or alcohol in the body. As we've said before, testing should relate to safely performing the job. Employers should use the least intrusive way of assessing impairment or fitness for work. The program or policy must not be arbitrary in terms of which employees are tested. However, as we talked about, testing employees in safety-sensitive positions may be permissible in some circumstances, and the policy gives a description of what safety-sensitive means. Finally, employers must provide individualized accommodation, that is, accommodation that responds to the specific needs of the person with the addiction. Blanket rules that don't consider a person's individual circumstances are likely discriminatory.
Wow, Anya, that's a lot to take in. How about a quick review?
Okay, so to recap, employers shouldn't wait until there's a complaint about their policy. They should design drug and alcohol testing policies or programs with the BFR test in mind. They should ask themselves the key questions that are laid out in our policy, take into account the key considerations and principles, and incorporate the elements of a well-designed testing program. These are laid out in the summary section of our policy, and we'll review these at the end of the webinar. A well-designed drug and alcohol testing program or policy that respects human rights may be justifiable under the code.
And that actually takes us to our next poll question. Does your organization have a drug and alcohol testing program? You can answer yes, no, no, but it's being considered. Let's see what we have here. So I think we have a number of people responding no. So I think the next section should be, oh, there's more coming. So the next section, yep, should be very helpful. Okay, I'm going to flip it. Just give us a moment here. Okay, so let's hear about the various drug and alcohol testing situations. I understand that different approaches will apply to different types of situations.
That's right. And before I go any further, there's actually a chart at the end of the policy. So if you do have a policy in front of you, or if you have it online, you can always follow along with the chart, and then we'll go through these such situations. So let's think about that example of the applicant who's asked to do an alcohol test before getting the forklift driver job. Testing for alcohol or drug use sometimes takes place before a person is hired, transferred, or promoted. It also might happen before contractors are allowed to start work on a client's job site. The OHRC takes the position that drug and alcohol testing as part of the initial applicant screening process, such as during the application process or the interview, is not allowed under the code.
And what about the person, if the person receives a conditional offer for a safety-sensitive job?
The OHRC recommends against testing in these situations, and here's why. If a person isn't hired because they test positive, it may lead to a finding that they're perceived to have a disability, even if they don't have an addiction. And that's because even if a person fails a test once, they're considered to be unfit for work in the future. This could be seen to treat them as if they have an ongoing disability. And refusing someone a job because of a perceived disability is discriminatory unless the employer can justify it as a BFR. Also, any medical testing should be able to assess whether a person can do the essential job duties. A drug or alcohol test done before the person starts working can't show that they're going to go to work impaired. And if an employer can't show this, it's going to be difficult for them to justify this type of testing as bona fide.
So Anya, using drug or alcohol testing as a form of job screening, may that be a violation of the code?
Yes.
So other than testing, are there ways to address a situation where someone looks impaired by drugs or alcohol while on the job?
Yes. Keep in mind that testing isn't automatically needed for employees who appear impaired at work. There may be other methods to address this, such as giving people a chance to explain what's happening, explain their behavior, what's happening with them, temporarily removing them from safety-sensitive job duties for immediate safety if they do truly appear impaired, offering accommodation to the point of undue hardship, and we'll talk more about this later. So this could be referral to an EAP or support to attend treatment, progressive performance management, and asking the person to get a medical assessment where there are valid reasons to be concerned.
Anya, could you talk a bit more about reasonable grounds and post-incident testing?
Sure. Reasonable grounds and post-incident testing for either alcohol or drugs may be acceptable where there's a link between impairment and doing a safety-sensitive job. Reasonable grounds testing should rely on objective evidence, for example, somebody appearing to be impaired by alcohol or drugs. An employer might also do testing after workplace accidents or near misses, and where looking at the employee's condition is a reasonable part of the investigation.
But the test should be just one part of a larger program, right?
That's right. Both of these types of testing should only be used if they're necessary as part of a larger process of assessing drug or alcohol addiction. This process includes a broader medical assessment and can include referrals to employee assistance programs or EAPs, drug or alcohol education, and other measures. And the employer must meet its duty to accommodate employees with addictions who test positive.
Let's think about that example you gave at the beginning, where the mining operation wants to start a program of random testing. Would this be allowed under the code?
Random alcohol testing. Well, the answer is it depends, right? With a lot of drug and alcohol testing, it depends. Random alcohol testing may be allowed in narrow circumstances. Because it can measure current impairment and meets other criteria, random alcohol testing by breathalyzer may be allowed in specific situations. These include employees being in safety-sensitive positions, but only where they're not supervised or they get minimal supervision. There's also evidence of risk in that particular workplace, and the employer meets its duty to accommodate people with addictions who test positive. Random drug testing may be allowed if it could be shown to measure current impairment as opposed to detecting recent use and meet other criteria. However, right now, there's still no drug test that's comparable to the alcohol breathalyzer in the sense that it's able to measure current impairment, can give fast results, it has a high level of accuracy, and is minimally intrusive. Employers who put in place random drug testing make themselves vulnerable to human rights challenges. If random drug testing were shown to meet these factors, it may be allowed in similar situations as random alcohol testing.
Anya, could testing be justified when an employee is returning to a safety-sensitive job after treatment for an alcohol or drug addiction?
Yes, in some circumstances. An employee might be expected to meet certain conditions when they come back to work following treatment, including unannounced testing. But any back-to-work conditions should be tailored to the person's individual circumstances. The testing period set should be reasonable, and the frequency of testing shouldn't be overly intrusive. And if the employee relapses, the employer still has to meet its duty to accommodate.
Let's talk more about the duty to accommodate. What should happen after a positive test?
The OHRC takes the position that a positive test triggers the duty to inquire into possible disability. This must be done respectfully and in a way that protects the employee's confidentiality. So after a person tests positive for drugs or alcohol, employees should be offered to attend an individualized assessment. This should be done by somebody who has expertise in substance use disorders. The person would assess whether the employee may have a disability and would identify any support that they might need. If a person is assessed and has a disability, the employer must offer accommodation unless it causes undue hardship.
What kinds of accommodation might an employee need?
If a rehabilitation program is what's needed, the employer must provide the support necessary for the person to go, unless this would cause undue hardship. Other types of accommodation include a referral to an EAP, modifying the person's duties, or providing them with alternative non-safety sensitive work. It really would depend on their individual needs. As well, disability should be a mitigating factor in considering if discipline is at all appropriate.
So Anya, the accommodation process is a shared responsibility. Where can our participants find more information about these responsibilities?
The policy has a section that describes the responsibilities of employees, employers, unions, and others. We don't have time to cover these today in the presentation, but I'd be happy to take any questions about these at the end. So about undue hardship. The employer is not required to accommodate the needs of an employee with an alcohol or drug addiction if it can be shown that the accommodation would cause undue hardship. This means that the cost of the accommodation is so high that it would change the nature or affect the viability of the organization. When determining this, employers must take into account any outside sources of funding that they can use or other ways that they can reduce the costs. The other way that an accommodation might cause undue hardship is if it caused significant health and safety risks. The health or safety risks to workers, members of the public, or the environment must be so serious that they outweigh the benefits of accommodation. And this can only be determined after accommodations and precautions to reduce the risks have been made. So employers can't just claim undue hardship based on their own impressions or stereotypes. They have to use objective evidence to prove it, and this can be difficult. In the case of undue hardship based on costs, this evidence has to be quantifiable.
Now, we often get questions about recreational users.
Right. The policy also includes a section on recreational or casual users of drugs or alcohol. So there's been a lot of controversy in legal cases around this issue. That is, in what circumstances is a recreational user considered to have been perceived to have an addiction, and therefore would fall within the protection of the code? Courts and tribunals in different jurisdictions across Canada have come to different decisions about this. Our policy reflects the case law from Ontario.
So when are recreational users protected by the code?
In two situations. One, where the employer subjectively perceives the person to have an addiction. So, for example, a manager who suspends somebody because she thinks he has an alcohol addiction. But they may also be protected if the testing policy or program treats the person as if they have an addiction. So this could happen if an employer imposes harsh consequences on a person, such as automatically firing them for testing positive.
What ways are there to address health and safety in the workplace other than drug and alcohol testing?
As I've mentioned, employers should use the least intrusive way to assess impairment or fitness for work. Some of these alternatives could include performance tests that can test for cognitive or psychomotor impairment, health promotion programs, substance use education and awareness programs, employee assistance programs, which can get at the root causes of addiction, training supervisors or others to assess behavior that can affect workplace safety, including signs of somebody being under the influence of alcohol or drugs, unannounced and planned checks, and peer monitoring. To sum up, a well-designed drug or alcohol testing policy that respects human rights may be justifiable under the code. This can happen if it is based on a rational connection between the purpose of testing, which should be safety, and performing the job, shows that testing is necessary to achieve workplace safety, is put in place after less intrusive methods for detecting impairment and increasing workplace safety have been explored, is used only in limited circumstances, such as reasonable grounds, post-incident or post-reinstatement situations, does not apply automatic consequences following positive tests, does not confuse substance use with substance addiction, is used as part of a larger assessment of drug or alcohol addiction. So aspects of this could be EAPs, drug education and awareness programs, and a medical assessment to inquire into possible disability-related needs. Provides individualized accommodation for people with addictions who test positive to the point of undue hardship. Uses testing methods that are highly accurate, able to measure current impairment, are minimally intrusive and offer fast results. Uses reputable procedures for analysis, and ensures the confidentiality of a person's medical information and the dignity of the person throughout the process.
Okay, thank you, Anya. Now we're going to start the question and answer segment of the webinar, and you can ask your questions in the Q&A pod. Now, please remember that we cannot provide legal advice. If you have a human rights complaint, you may want to consult with the Human Rights Legal Support Center. If you have a complaint filed against you and you are, for example, an employer or service provider, you may wish to consult with your own legal counsel. During the questions and answers, we may pause and there will be silence at our end. This is because we may need just a few moments to consider the question. Okay. And we're getting a number of questions popping up here. Let's start with a question that's come up fairly often. And that is, can you fire an employee for failing a drug or alcohol test?
Yeah, it's a good question. So employers that automatically dismiss employees for testing positive for drugs or alcohol make themselves vulnerable to human rights complaints. A response that would better respect people's human rights is to inquire into possible disability and people's related needs, disability-related needs, and then offer individualized accommodation to the point of undue hardship. So, and then again, like a person's disability would be considered a mitigating factor when considering if any discipline is appropriate at all. So, and even if an individualized assessment finds that somebody is a casual user or recreational user, automatic dismissal, as we've learned, may be evidence that the drug or alcohol policy treats the person as if harshly and as if they have a disability. So this type of action could be found to be discriminatory based on perceived disability. So in these situations, we recommend that the employer consider discipline that's tailored to the circumstances and to people's to what has happened to precipitate the drug or alcohol test.
Okay, thanks, Anya. Let's just take a look at some other questions here. Just bear with me for one moment here. A common question that we often receive is about drug and alcohol testing is whether or not there's a difference in unionized versus non-unionized environments. Can you talk a bit more about that, Anya?
Sure. So the Human Rights Code and our policy will apply to both unionized and non-unionized environments, and the requirements of the code are the same, whether the environment is unionized or non-unionized. The principles around the duty to accommodate, for example, are the same, regardless of the environment. And unions also have a particular role to play to facilitate accommodation and to make sure that collective agreements can't act as a bar to providing accommodation. So a lot of the legal decisions around drug and alcohol testing have come out of a grievance and unionized environment. There are grievances, they make their way to labor arbitrators, and then they go sometimes to the courts. So many of these cases are analyzed both from the perspective of human rights law and also from the perspective of whether employees' privacy rights under the collective agreement are being appropriately balanced with risks to health and safety. So privacy is a key consideration for all employees and employers, but it appears to be a key consideration for a lot of the claims that come up under the collective agreement. And also, with respect to random testing, from the perspective of our policy to justify random testing under the code, both unionized and non-unionized workplaces would have to be able to show that there's evidence of risk that exists in a particular workplace. For example, that the work is highly dangerous, for example. However, in claims that relate to employees' rights under a collective agreement, there could be additional obligations under the collective agreement.
Thank you. Now, we have several questions pertaining to medical marijuana. So I'll just frame one. Does the policy deal with how to accommodate employees who use medical marijuana?
Okay. So yes, so this is a kind of a hot topic, and whenever we start talking about drug and alcohol testing, we hear questions about medical marijuana. It's a burning issue for many employers and employees too. So the policy itself doesn't specifically speak to employees who use medical marijuana. However, it does include the general principles around the duty to accommodate. So, and these principles are elaborated on, and you can find more about them in our recent released policy on ableism and discrimination based on disability, which is on our website. So that's our updated disability policy. So I can say that medical marijuana it's a legal form of treatment, and it has been since around 2001, that people may use to help with disability-related symptoms. So employers might receive accommodation requests from people who want to use medical or required to use medical marijuana. So it's good to keep in mind that not all types or dosages of medical marijuana will cause impairment. So for safety-sensitive physicians, looking at whether medical marijuana use will cause impairment that will create health and safety risks will be a consideration. And if it does, then employers have to see if they can take steps to reduce the risk somehow so the person can perform the essential job duties. If the risk can't be reduced, it may constitute undue hardship based on health and safety to accommodate somebody in their original position. But that's not the end of the duty to accommodate. Other next best solutions would need to be explored, such as the person doing alternative work.
Okay, we're just scrolling down through the questions here. Here's one question. How much information can the employer know about a person's addiction?
Okay. So what we've said is that a positive test will trigger the duty to inquire into whether the person has a possible disability and see what their related restrictions and limitations are and what accommodation they might need. So the employer would know the results, the test results, right? So that somebody has tested positive for a substance that's banned under their policy. And if an employee agrees to be assessed, then the employer would know that the person has a disability, and they'll also know their restrictions and their limitations and any potential accommodation that they might need. However, an employer is generally not entitled to know a person's private medical information, such as the cause of their disability, their symptoms, or their diagnosis. In limited circumstances, more information may be needed because it relates specifically to the accommodation that's being requested or that's needed, or the person's needs are complex, challenging, or unclear. And in these cases, employers can request more information from the person, up to including a diagnosis. But the employer would have to clearly show why this information is necessary, and to only ask for information that's reasonably related to the accommodation request and the person's restrictions and limitations. So at the end of the day, even if the employer knows that the person has tested positive at a certain threshold for something that's been banned under the policy, and they need time off to attend, to attend treatment, for example, they're generally not entitled to know, for example, that the person has a cocaine addiction and attends Narcotics Anonymous meetings. So any medical information of a private nature should be kept away from the person's personnel file.
Okay, let's just scroll down, and here's a question on an employee's fluids, collecting fluids. Why isn't it an obvious violation of human rights to do mandatory collection of an employee's fluids or breath that could reveal disability?
Mm-hmm. Yeah, so I mean, it's for many people it may sound intrusive to do these kinds of tests, etc. And certainly there's lots of claims around where does that line fall between health and safety and protecting employees' privacy. So it's not automatically discriminatory, though, based on disability to collect an employee's bodily fluids or breath. It does raise privacy concerns for employees with disabilities and also people without disabilities. So the reason for these kinds of programs is generally to detect people who pose a health and safety risk in safety-sensitive jobs because they're impaired by drugs or alcohol. And it could be that both people with addictions and people without addictions may fall into that category. Testing positive for any kind of substance doesn't constitute proof that the person has an addiction. So one can't assume that just because a drug and alcohol testing policy is in place, it infringes people's right to be free from discrimination based on disability or perceived disability. And the case law has told us that the effect of the policy has to be examined in each case.
Okay, we have a question here, just bear with me, on refusing to be assessed. How do employers deal with refusals by an employee to be assessed by a substance use disorder expert, or refusing offers of accommodation, or refusing to comply with conditions when returning to work after treatment?
Okay, so this is a really good question. And actually, if you take a look at our website, we have a question and answer, an FAQ section. And this is dealt with there, so you might find that to be very helpful. So what happens if somebody does refuse? So maybe what I'll do is I'll just start with the refusal to be assessed by a substance use disorder expert. So somebody's tested positive and there's been an offer of an assessment, but the person doesn't want to be assessed. And so what does the employer do in those circumstances? So in our policies, we've been very clear that nobody can be made to attend a medical examination, but failing to respond to reasonable requests may delay accommodation until the information is provided. And it may ultimately frustrate the accommodation process. So an employer may not know how they can potentially accommodate somebody who they may believe has an addiction that's preventing them from doing their work without further information. If there are legitimate reasons to be concerned that somebody may have an addiction and it's preventing them from doing their job duties, they refuse to attend an assessment that can determine what their needs are, the employer would probably have to use some kind of progressive performance management, and alongside repeated offers of accommodation that need to take place to acknowledge that it may be very difficult for somebody to come forward and identify that they have an addiction potentially, or that they have a disability and they need support. But at the same time, there's also an obligation on the part of the employer to be able to manage that person's performance.
Now we have a question on paying for treatment. So does an organization have a responsibility to pay for someone's treatment?
Well, employers are required to provide the support that the person needs to attend treatment, if that's what they need. And generally, employers are required to bear the costs of accommodation unless it causes undue hardship. However, human rights law hasn't really decided whether this would include the cost of treatment, such as therapy, medication that a person needs to be able to do their essential job duties. So many organizations, as part of the benefits that they offer to employees, will provide access to an employee assistance program and at least some partial funding for treatment programs.
Okay, a question on continuing accommodation. Does the employer have to continue to accommodate someone with a drug or alcohol addiction if they relapse over and over again?
That's a really good question. And I think that there are a lot of employers out there who are wondering, okay, well, what are the limits here on the duty to accommodate? So, and I think that it's important to recognize that many people have disabilities, including people potentially with addictions, that may be chronic in nature, and that many people will need time off or accommodation at some point in their careers when they experience symptoms of disability, and there may be periods of wellness and then periods of disability again. So people with addictions to drugs or alcohol have the same right to be accommodated as people with other disabilities. The limit to accommodation is undue hardship, which the code tells us amounts to really two things: excessive costs or significant health and safety risks. However, the policy does recognize that there are other very limited circumstances where an accommodation that wouldn't cause undue hardship would still not be required, because either it would fundamentally change the nature of the job or the employment, or it still wouldn't allow the person to fulfill the essential duties or requirements of the job. So this could apply to situations where the employer has tried many times to accommodate the person, but even after these attempts and the person has long absences, the person can't come back to work in the foreseeable future. So at some point, the employer's duty to accommodate will come to an end. So, but I do want to emphasize that these are likely rare circumstances, and the employer should not jump to this conclusion right away. It still has an obligation to meet its procedural duty to accommodate. That is looking at issues and solutions on a case-by-case basis and seeking out next best solutions, etc.
Yeah, you're just hearing some silence right now because we're just going through the questions and we have a lot of them. So please bear with us. Thank you. Just hold on. Okay, we have a question from Art. If an Ontario-based employee who travels to the U.S. is requested to take a drug test there is as a result of a motor vehicle accident or act, is it discriminatory in Ontario?
Well, Art, that's a great question. So it's actually out of the jurisdiction of our policy because truck drivers who go to the U.S. Or across provinces would fall under the Canadian Human Rights Act. But there has been some case law that went to the Canadian Human Rights Tribunal where the Department of Transportation requirements to, for drug testing, et cetera, that were imposed on Canadian truck drivers or bus drivers were thought to be a bona fide requirement. However, the employer still had a duty to accommodate that person if the person has an addiction in Ontario. So hopefully that responds to your question. But there's also a related question that sometimes there are third-party requests, like client requests, et cetera, to do drug and alcohol testing. So a customer requests to put drug and alcohol testing in place. And just because there is a third-party requirement to put it in place doesn't mean it's automatically a bona fide requirement. So the organization would still have to show that it would have to go through that three-step test to demonstrate that it's a bona fide requirement. So just having somebody else who's telling you, your organization, you have to put testing in place, that's a requirement, doesn't automatically make it non-discriminatory.
Okay, another question. Can employers in non-safety sensitive workplaces set up drug and alcohol testing policies?
Right, and so I imagine that maybe a lot of people who are listening are potentially not employers in safety-sensitive environments or don't have safety-sensitive positions, and it is a good question. Could you set up a drug and alcohol testing policy, for example, if the purpose of the testing policy was productivity or wellness or reducing absenteeism, that kind of thing? And what we have said is not likely. So the case law that exists in Ontario and in Canada, the human rights and arbitration case law, it deals really with drug and alcohol testing in the context of safety-sensitive positions and dangerous work environments. So employers, of course, need to consider the code, but they also have to consider employees' rights to privacy. And because of the potential to intrude on privacy, drug and alcohol testing can only be justified in very narrow circumstances where there's health and safety concerns in these dangerous work environments, which people are doing safety-sensitive work. So drug and alcohol testing that has no demonstrated relationship to safety, job safety and performance, where there's been no evidence of enhanced safety risks in the workplace, has found to violate employees' rights. And that focusing on these other kinds of things, other requirements such as performance, et cetera, or productivity, et cetera, it would be difficult to justify as bona fide requirements. If these policies then lead to people being fired or dismissed, et cetera, and lead to negative consequences, because they may be actually used to single out people who are thought to have addictions, and that in itself can be prima facie discriminatory. And there may be lots of other ways to be able to justify, or lots of other ways to be able to determine somebody's performance or increase their performance, as opposed to the very intrusive method of drug and alcohol testing.
Okay, a question on safety-sensitive positions. Can employers ask employees in safety-sensitive positions to disclose if they are impaired and can't do their essential duties?
This is a really good question as well, and I think that this also comes up in terms of medical marijuana. I mean, we don't have a position on medical marijuana, but this is a good question because there could be lots of things that are impairing people in safety-sensitive positions where they may be unsafe to work in that position. They may be, such as extreme fatigue, for example, or stress, extreme stress, or other kinds of issues, other disability-related symptoms. It's not only just drug and alcohol use, right? So, so for people in safety-sensitive position, I would say it is reasonable for employers to know if employees are not fit to do their essential duties, and it's also reasonable for employers to expect employees to do their duties in a safe manner. So they may have policies in place to ask people to disclose whether or not they are impaired, to inform them if they're impaired. That is, they can't do their job safely because there's some kind of loss in body function, etc. So where these kinds of things are preventing somebody from doing the essential duties of the job, the employer can ask the person whether they're impaired or they have particular restrictions or functions or restrictions or etc. And where these impairments and restrictions relate to a disability, of course, the employer has a duty to accommodate these by finding solutions, such as modified duties. But again, the employer is not generally entitled to know the person's private medical information. But one thing that employers should really keep in mind if they do have these disclosure policies in place is that there are real potential negative effects that these policies can have on people with disabilities. So somebody with an addiction may not be able to recognize that they have an addiction. They may not be able to disclose their disability because of denial that's associated with the disability. There may be severe stigma that is surrounding an addiction that is also making it very difficult to recognize that they even have a disability. So our policy on drug and alcohol testing says that in these circumstances where people are not able to recognize that they have an addiction, policies that would discipline them for not coming forward and disclosing that they have an addiction may be found to be discriminatory.
Okay, question on the OHRC's policy. Does the OHRC's policy take a position on the type of treatment a person with substance addiction should receive?
No. Seeking treatment is a very, very personal issue, and what's required will be based on a person's needs. So one approach that might work for one person will not work for somebody else. And it's really up to the person and their own support, medical support, and personal professionals. Two types of approaches that I'm aware of are abstinence-based and harm reduction approaches. And the employers are really, their duty is to provide the support necessary, such as time off for the person to go to treatment. Or whether it's a rehabilitation program or not, if treatment is what the person needs, there could be other things that the person needs, unless these things were to cause undue hardship for the employer.
We've got several more questions on random testing. Let's see. What does the additional requirement of, quote, where the employer is able to demonstrate risk in the workplace mean for an employer that wants to do random testing? What might an employer have to know beyond the essential duties of the position, of the position involving safety-sensitive work to justify random testing?
All right. So as part of showing that random testing is justified as a bona fide requirement, the employer may be expected to show that there's the kinds of risks that are inherent in the workplace. So like that the work is highly dangerous, or the kinds of consequences that may happen as a result of accidents or mistakes. And the employer may also be required to show that there's a problem with drugs or alcohol addiction in the workplace to justify random testing or other types of testing. And I can tell you that this was the case in the one Ontario arbitration case. And so it was a case that was about pre-access testing. And because the organization couldn't show that there was like a general problem with drug or alcohol use in the workplace, this kind of testing, the pre-access testing, was found not to be a bona fide requirement. So, and this requirement comes out of, I guess, a relatively recent, in 2013, Supreme Court case involving Irving Pulp and Paper. And so the court held that while the dangerousness of the workplace is highly relevant, really there's evidence of enhanced safety risks, such as evidence of a general problem with substance abuse in the workplace, is also required. So this case was decided in the context of a unionized environment, but it did state that the court did state that even in a non-unionized workplace, an employer must justify the intrusion on privacy resulting from random testing by reference to the particular risks in that particular workplace. So we've taken the position that this requirement then applies to non-unionized settings.
Okay, we have a question on measuring impairment. Can drug and alcohol test measure impairment?
So the focus of drug and alcohol testing should be to determine the actual impairment of an employee's ability to perform or fulfill the essential duties of the job at the time of the test. So alcohol testing by breathalyzer is seen to be fairly minimally intrusive compared to, say, blood tests. It's also a highly accurate measure of both the levels of what people are consuming and actual impairment. So the use of breathalyzers, alcohol breathalyzers, has found to be permissible under the code in narrow circumstances. So for drug testing, it is more difficult to measure impairment through drug testing. So even though there's methods that are better than others, some are better than others, nothing exactly can map onto impairment. And there's also some issues around what constitutes impairment, at what level are people, what's the threshold and the level where people are impaired. So those issues are still being worked out, although the science in this area is rapidly improving. So urinalysis can detect past use, but it can't detect how much of the drug was used or whether the person is currently impaired. And there's still limits to detecting impairment through other kinds of testing, drug testing as well. So what we've done in our policy, instead of saying this kind of drug testing is in or it's out or whatever in terms of random testing, what we've done is take a criteria-based approach. And you can see that if a drug test is able to meet certain criteria, it's more likely to be defensible, and an employer can use it. It's more likely to be able to be defensible under the code as part of the justification for random testing.
Okay, we have time for just one last short question. How many employers do drug and alcohol testing?
So I don't have recent stats, but there was a 2003 survey of 100 employers in Canada, and the figures varied widely between the provinces. So it looked like at that time 25% of organizations of this, 25% of this, I guess it was 25 of these 100 employers were doing testing in Alberta, and 4.6 were doing it in Ontario. So overall, the range was about 10.3%.
Okay, well, I guess that's it. All we have time for today. Thanks, Anya.
Thank you so
Dora,
much.
for presenting this topic today. Very timely and quite interesting to hear what the rules are. So thanks again. For those of you who attended today, thank you for joining us. Your feedback is important to us. Please take a few minutes to complete the survey that will be sent today. The recertification code for those